Hey everyone, welcome back to my channel. This is Laura from The Real Laura B here on YouTube and Twitter. Boy, we got a lot of documents this weekend. My eyes are killing me. I feel like they're bulging out of my head. I tweeted a ton and I'm going to try and do a live tomorrow or Wednesday, and I'll put that up to cover the unsealed documents from the Depp vs. Heard case. Today, I'm going to continue the insurance saga. Amber Heard's insurance companies suing each other. In the last video, the judge had dismissed the claim. But Travelers is now throwing a Hail Mary pass and essentially claiming, gee, Judge, you missed something. And oh, by the way, I think New York Marine's committing some kind of fraud. And that's what we'll be working on today for another deep dive. Hang in there. Hi, I'm Laura, also known as The Real Laura B from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. And here we are. Again, this is a deep dive, so I will be reading documents. I will be skimming over the legal case citings because I'm not going to investigate each one of them. We're going to have to assume what they're saying is true for the judge unless it's countered in the next motion. So I'll just do that skimming part. But yeah, let's get into it here and see what's going on. And here's the first document. So defendant, New York Marine and General Insurance Companies further briefing in response to Travelers' request for further order. So in the last video, the judge dismissed it, and then they were going to have a meeting, an updated a conference meeting, status meeting, that's the word. And the eve before, Travelers sends his email and says, oh, excuse me, but can you make sure the judge gets this because they're going to need it for our status meeting tomorrow? Well, it turns out that they filed something that New York Marine feels was a improper filing, almost like an ex parte filing, meaning it's an emergency, and the other counsel doesn't even know about it. So New York Marine didn't know about it. And they're essentially saying, hey, judge, there was this one paragraph that you didn't rule on. And that was, how are we going to handle the fact that Cameron McAvoy withdrew and stopped giving service to Amber Heard's defense? And that's who New York Marine was paying for. So how are we going to handle this? Because from that point on, it was our lawyer, our counsel that was defending her, and we should be reimbursed for at least half of that cost. So that's where we're picking up here. So they have, they're going to have a hearing. Again, this is all happening. This is February of 2022. So we're catching up. This is this year, but it's still before the trial's happening. So they, in their head, I think they still think Amber Heard's going to win. So right away, we'll get right into it. A lot of cases cited. Like I said, we're going to skim over those parts of the paragraphs because I'm really interested in the juicy story. Keeping in mind, everything that are in these motions are, again, allegations and shade. Right? Nothing's been proven. We just saw that with the Depp unsealed documents. There's a hell of a lot of shade in that, hell of a lot of unproven and unqualified statements. And nothing I haven't seen before except for the Manson text. But I'll get back to that. The court has already carefully considered the briefing and arguments presented and correctly concluded that the bulk of Travelers' allegations do not suffice to state a viable claim for relief. It was dismissed. In an attempt to salvage its first amended complaint, Travelers now points to an allegation therein asserting that New York Marine compounded its breach of duty to defend by having its appointed counsel do next to nothing and piggyback on the work of the mutual insured's independent defense counsel paid by Travelers, contending that this allegation suffices to independently support its claim for equitable contribution. They want their 50% of everything they spent. During the January 27th status conference, this court also referred to paragraph 31C of Travelers' first amended complaint, which in relevant part alleges that, alternatively, even if the court determines that New York Marine was not obligated to defend the insured with independent counsel, defense counsel of the insured's choosing, either because California law does not apply or for some other reason, we learned that Virginia law says that there's no conflict of interest, that whoever the insurance companies appoint or hire, they only serve the insured. They only serve Amber Heard. So there's no conflict of interest there. California does not apply or for some other reason. New York Marine still breached its duty to defend the insured by failing to provide it an adequate defense. This failure includes not paying attorneys to do adequate work to defend the insured and not replacing its chosen Virginia attorneys at all when they withdrew from the defense. However, for multiple reasons, Travelers' allegations, regardless of how they are characterized, fail to state a claim for relief for equitable contribution. First, as a threshold matter, Travelers lack standing to assert a claim for breach of contract, whether styled as such or as one for equitable contribution. As this court has already ruled, Travelers and New York Marine do not share a joint obligation to defend the insured through independent counsel. Further, defense counsel is an independent contractor, and thus their negligence, if any, cannot give rise to liability on the part of New York Marine. So if they claim that Cameron McAvoy stopped doing their job, that's on Cameron McAvoy. That's not on New York Marine. You're suing the wrong person. New York Marine breached both the terms of its policy and its duty of good faith and fair dealing towards their mutual insured. However, as this court recognized during the January 27th status conference, well-established California law makes clear that Travelers, as a stranger to the New York Marine policy, lacks standing to bring claims on the New York Marine policy in its own right, absent an assignment of rights from the insured, even if enforcement of the contract would have some ancillary benefit to it. And this is from the transcript of the hearing. Again, I agree with you that if in fact the plaintiff is only arguing that because the defense that was provided by the defendant's Virginia counsel was inadequate, I would agree the plaintiff has no standing to make that type of argument. No, Amber Heard has to be the one that's complaining, not Travelers. Amber Heard has to be the one to sue Cameron for not providing, or New York Marine for not providing an adequate defense. Travelers impliedly admits that it has no assignment of rights from the insured, from Amber Heard, and thus cannot pursue a breach of contract claim in its own right. Just a reminder, you're not going to see Amber's name here. They did everything they could so this could not be found before the trial. So she's often referred to as insured. The judge referred to her as ALH. It is also the case that under well-established California law, in the absence of an assignment, one insurer's claim against another insurer for an alleged breach of the insurance policy arises only in subrogation. Let's see. I had this on silent. Let's see. Anything good in the footnotes? Sometimes there is. In this respect, Travelers sues in its own name, not the insured's. Does not allege an assignment. In other words, that Amber Heard is assigning to Travelers to go sue on my behalf. And in response to the direct question from this court during the December motion hearing, why doesn't the insured sue in her own name? Travelers' counselor impliedly conceded that the insured wasn't suing in her own name by asserting instead that because Travelers stepped up, by reason which the insured has not been damaged. At base, however, the face of the pleadings established that Travelers has sued in its own name, not in the name of or on behalf of its insured. There is no allegation that Travelers intends to share any recovery with the insured, and indeed, Travelers' first amended complaint does not allege that the insured is even aware of the present litigation, much less that it ever consulted her in respect to this suit, or somehow acts on her behalf in her interest or in furtherance of any interest but its own. So Amber Heard's defense has been paid for. She probably doesn't know about this litigation, or although she probably does because this Pamela Johnson was with her constantly. But Amber Heard's not the one being harmed here. Her defense got paid for. I mean, the one counsel left, but she had other counsel. There was no complaints in the court in Virginia that she was underserved in her legal counsel in any way. It's Travelers who's suing New York Marine because they ended up footing the majority of the bill, almost $8 million, especially after Cameron McAvoy withdrew. So they're right. This is an issue between Travelers and New York Marine. And if Travelers was awarded any money, they weren't going to be sharing it with Amber. So let's go on. Travelers' attempts to couch its inadequate defense claim as one for equitable contribution simply does not suffice to establish a viable claim against New York Marine. Rather, the relevant allegation here that New York Marine had its appointed defense counsel do next to nothing is plainly predicated on New York Marine's alleged breach of its duty to the insured to provide a defense under the policy. However, California law established that an insured who has been provided a full defense by one insurer has no damages on account of another insurer's breach of the duty to defend and thus has no basis to make such a claim. So Amber Heard's fine. She was taken care of. Since Travelers admits that it provided a defense to the insured, it follows that the insured cannot have suffered any damages as a result of the alleged inadequate defense provided by New York Marine. Thus, even if Travelers' first amended claim alleges a claim for inequitable subrogation, that claim still would not be viable. Further, and given Travelers' failure to plead specific facts supporting its allegations, it bears nothing that Travelers' allegations simply aren't true. Rather, as reflected in the extensive correspondence between New York Marine, its rightfully appointed defense counsel, the firm Cameron McAvoy, and Travelers, which the court should consider under the incorporation of reference doctrine recognized by the Ninth Circuit, Cameron McAvoy firm was originally retained by the insured long before the tender to New York Marine or its acceptance of the defense under a reservation of rights. Amber Heard hired Cameron McAvoy on her own. New York Marine just accepted the counsel already was working for her, and they picked up the defense tab for Cameron McAvoy. In doing so, it clearly expressed its intent that it act as lead counsel in the insurer's defense and have an active role in the litigation, and fully anticipated that it would do so since they were initially retained by the insured. Keep in mind also that this is a Virginia case. They needed a Virginia lawyer. At the time, she had Eric George, California lawyer, and Cameron McAvoy. At the very time that New York Marine, that she filed, New York Marine took on Cameron McAvoy, Robbie Kaplan came in, and so did Ben Rottenborn, local Virginia counsel. And that's who Travelers decided to pay for. And they were like, yo, dude, we're already here working on this. I understand and then Eric George left after that. So she had a lot of lawyers working on this at some point. And we will get a declaration. I hope we see one of Sean Roach. We don't, that's from Cameron McAvoy. We don't always get all the attachments. Well, let's see. The correspondence and declarations also reflect that New York Marine's appointed defense counsel was cut out of participatory role in the insured's defense by the independent counsel retained by the insured and by Travelers. And I saw this in the motions, and it was very strange. As soon as Kaplan came on and brought in Ben Rottenborn, who was the Virginia lawyer, all the motions that were coming up on the Fairfax site at the bottom of after the signature line, you'll have all the list of attorneys for defense counsel for Amber Heard, all the list of plaintiffs' counts. Cameron McAvoy was dropped off the list, completely disappeared. His name was never shown again. Moreover, the correspondence and declarations established that Travelers knew of appointed defense counsel's difficulties in this regard, but failed to require, as it was legally entitled to under Civil Code 2060, the independent counsel cooperate with Cameron McAvoy. So they were required to tell Kaplan and Rottenborn, you got to work with this guy. Okay, so more tea in the footnote. New York Marine submits that Travelers' allegations that New York Marine had appointed defense counsel do next to nothing necessarily implicates New York Marine's oral and written instructions to defense counsel. Emphasis added. They can't bold it. Emphasis added. Accordingly, New York Marine hereby submits the identified declarations and accompanying correspondence between itself and its appointed defense counsel and Travelers, filed herein as exhibits, and to the declarations of Sean Roach of the firm Cameron McAvoy and of Mr. Stephen Battaglia, ProSite Specialty Management Company. I think they're their underwriter. So they go on to say, look, motion by this rule prevents plaintiffs from surviving the rule motion by deliberately omitting references to documents upon which their claims are based. Here, the allegations of Travelers' first amended complaint, and particularly paragraph 18, which alleges that New York Marine compounded its breach of duty to defend by having its appointed counsel do next to nothing and piggyback. It's a heck of a claim against a lawyer. On the work of the mutual insured's independent counsel paid by Travelers inherently refers to the communications between Cameron McAvoy, New York Marine, and Travelers, which contradict these allegations. They were saying, look, they're not giving us anything. They're not telling us anything. The provision states where the insured selects independent counsel pursuant to the provision of the section, both counsel provided by the insured and independent counsel selected by the insured shall be allowed to participate in all aspects of the litigation. Counsel shall cooperate fully in the exchange of information that is consistent with each counsel's ethical and legal obligation to the insured. Nothing in this section shall relieve the insured of his or her duty to cooperate with the insured under the terms of the contract. Now, this is pretty tough on Cameron McAvoy because let's say in the end, if they had left, if Amber Heard said, you know what, you guys really messed up my defense and I'm going to sue you for malpractice, McAvoy would have been part of that lawsuit, even though they were being ignored and not able to defend Amber Heard. And they don't want that kind of responsibility. Moreover, Travelers' first amended claim includes a series of related allegations, which, when read together, may be fairly read to sound in fraud. Specifically, in addition to the allegation in paragraph 18 of an inadequate defense, it also alleges that New York Marine's conduct had been deceptive, that while purporting to defend New York Marine, had its appointed defense counsel do next to nothing and piggyback on the work of the mutual insured's independent defense counsel paid by Travelers. And also that New York Marine has indicated that after trial, it will likely attempt to deny coverage for any award against the mutually insured based on its reservation of rights. Stated otherwise, Travelers is accusing New York Marine of having represented that it was defending, but then deceptively not doing so. However, such conclusory and factually devoid allegations do not satisfy the heightened pleading standard required by the rule. I mean, that's a pretty high standard there. For claims sounding in fraud, which must allege with factual specificity the who, what, when, where, and how of the misconduct charged. Furthermore, as alleged in paragraph 20 of the First Amendment complaint, New York Marine advised Travelers that it would pay 50% of the fees and costs incurred by independent defense counsel on or after November 20th, which is when Cameron McAvoy withdrew. In fact, defense counsel withdrew on November 6th, not November 20th. And then you will see the Roche Declaration. And contrary, I hope you will, and contrary to the assertion in paragraph 31 that New York Marine has not replaced its chosen Virginia attorneys at all, when they withdrew from the defense, New York Marine agreed to participate with Travelers. So since New York Marine did not replace Cameron McAvoy, they said, okay, we will now help you out. But they only pay for one lawyer. And at that time, it was with the Charleston Bredehoft firm. And Travelers has paid, and they had paid Travelers. Now remember, Travelers said, we never got a penny from New York Marine. They said, well, wait up. We have already paid you over $621,000 in reimbursement for sums paid to Charleston Bredehoft for those services following the withdrawal of Cameron McAvoy. From November 6th, see the January 20th declaration of James Wagner. We do have that one. Accordingly, Travelers' claims should be dismissed, notwithstanding the inadequate conclusory and complete inaccurate allegations of paragraph 18. Alternatively, at the very least, if the court believes that Travelers' allegations suffice to sustain some element of its claim, it should require that the Travelers amend its complaint to allege the factual detail required by the federal rules of civil procedures. Now, they do a lot of repetitive claims here, so we may skip a bit. Travelers are standing to assert a claim for breach of contract, whether styled as a claim or breach of contract or one for equitable contribution under the law of California, which, as shown by the January 6th ruling on the motion to dismiss, the court considers applicable. It is axiomatic that someone who is not a party to the contract has no standing to enforce the contract or to recover extra contract damages for wrongful withholding of the benefits of the contract party. The contract party is Amber Heard, not Travelers. Moreover, it's equally the case that the insured context non-party who is nevertheless entitled to policy benefits, such as an insured person under the terms of the policy, has standing only if he or she is the claimant whose benefits are wrongfully withheld. Anything in there? We are assuming the California law. No. So California law precludes enforcement of a contract by persons who are only incidentally or remotely benefited, and that would be Travelers. Your Travelers admits that it is not an insured under the New York Marine policy and does not contend that it is suing on an assignment of rights from Amber Heard, nor does Travelers allege a joint defense agreement or other contract under which it would be entitled to assert a direct claim against New York Marine. Remember, they had separate counsel, so they weren't working it together, paying each other's counsel in the beginning. New York Marine was paying Cameron McAvoy, and Travelers was paying the counsel they appointed or accepted. Travelers has no standing to assert a claim for a breach of contract between New York Marine and its insured, Amber Heard. So we went through that already. Travelers cannot salvage its contract-based allegation by couching them as a claim for equitable contribution. an attempt to salvage its claims while tacitly acknowledging that it cannot directly assert a claim for breach of contract. Travelers instead contends that the allegation that New York Marine failed to provide an adequate defense for its insured provides an alternate basis for it to recover on theory of equitable contribution. They do not share a joint obligation to defend the insured. Under California law, contribution is an equitably remedy which is separate and independent from the insured's contractual right to benefits from the targeted insurer, since the insurer seeking contribution is a stranger to the targeted insurer's policy and does not stand in the shoes of the insured with respect to the insured's entitlement to contractual benefits under the targeted policy. Travelers cannot benefit from New York Marine's policy and vice versa because they're not a party to the contract, only Amber Heard. And she hasn't asked them to stand in her shoes. She hasn't assigned them any rights. Numerous cases have reinforced this principle. Critically, a claim for equitable contribution is premised on a joint or shared obligation by insurers which provide coverage at the same level for the same risk. So New York Marine is saying, when we had Cameron McAvoy, we're not obligated to give you an equitable contribution for the lawyers you chose to hire. Now, go after Cameron left and we decided to work with your lawyers, we offered to pay the 50%. As an initial matter, to the extent that Travelers extends that its allegation that New York Marine intentionally told its defense counsel to do next to nothing and piggyback on the work of the mutually insured's independent defense counsel paid for by Travelers amounts to a valid independent justification for its claim of contribution. That allegation on its face is simply insufficiently pled. As the Supreme Court has stated, a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference from the defendant. So she has to do the who, what, where, when, and what. Like, how did they actually have a deficient claim here? Defense. The court is not required to accept as true allegations that are merely conclusory, unwarranted deductions of fact, or unreasonable inferences. Here, however, the allegation on which Travelers' basis is its remaining claim that New York Marine provided an inadequate defense is initially predicated upon Travelers' already mistaken insistence that New York Marine was obligated to defend through independent counsel. In that regard, Travelers' First Amendment claim alleges in paragraph 17 that New York Marine appointed defense counsel of its choice, and it repeatedly refused demands by the mutually insured and by Travelers to participate in defense with counsel of mutually insured's choosing. Only thereafter does it allege that New York Marine compounded its breach of the duty to defend by alleging having its appointed counsel do next to nothing. So let's remember the history. Amber Heard had already hired Cameron McAvoy. Both their letters, Travelers and New York Marine, both state we have a right to assign you counsel. We have a right to pick the counsel for you. Then Travelers turned around and says, oh, no, we don't get to do that. You get to pick your own counsel. The judge agreed with New York Marine that in Virginia, with their law of no conflict of interest, because the counsel only serves the plaintiff and not the insurance companies, that it was perfectly fine with New York Marine picking up Cameron McAvoy, who had already been hired, as their attorney of choice. So they weren't responsible for paying the other one. And apparently Amber Heard never complained or fired Cameron McAvoy. So New York Marine was doing the best that they could do, bringing the proper defense. It is apparently undisputed by Travelers that it is obliged to defend the insured through independent counsel, inasmuch as it admits that it has done so and continues to allege that New York Marine is also obligated to do so. However, this court already determined New York Marine has no cumulus counsel obligation. That's that no conflict of interest, that she gets to pick her own counsel in connection with a Virginia attorney's representative of the insured in a Virginia lawsuit. We went through that with the last, and I've touched on that a couple of times. No conflict of interest. From Travelers' allegations and the court's conclusions, it necessarily follows, contrary to the allegations on those paragraphs, New York Marine did not breach its duty to defend by failing to appoint independent cumulus counsel. They appointed Cameron McAvoy. That as a consequence, New York Marine can have no shared obligation with Travelers to provide a fund or defense for the insured through independent counsel, through their counsel. We had two counsels going. I paid my bills. You pay your bills. As a result, because Travelers and New York Marine are not jointly at risk to provide independent counsel, Travelers cannot state a claim for contribution against New York Marine grounded in the notion of shared obligation to fund independent counsel. Since the defense counsel acts as an independent contractor, a negligent defense does not give rise to liability on the part of the New York Marine. And I'll skip this. Basically, they already covered that. Hey, if you didn't like the work that Cameron McAvoy did, go sue them. We're not obligated. They're an independent contractor. We're not responsible for their work. Yes, furthermore, since a claim for malpractice does not run to third parties, New York Marine, and it's unassignable under both California and Virginia, traveler's claim likewise cannot be sustained on that basis. You're suing the wrong people if that's the path you want to go down, which I feel bad because it sounds like Cameron McAvoy was being ignored and they're being thrown under the bus here. Okay, since Travelers is not a party to the New York Marine policy, it's a stranger to the contract. We covered that, so they can't claim that New York purported breach of its duties. Because New York Marine owes no duty to travelers, a claim cannot be stated by travelers against New York Marine for equitable contribution on account of alleged breaches of any duties owed by New York Marine to the insured. And this is, again, restating a lot of things from above. Probably don't have to go that way. Okay, here we go. Insured received a full and complete defense notwithstanding the breach. So this is going to be, they're citing case law. Where defending insurer paid a portion of plaintiff's legal expenses before withdrawing from defense, and a separate insurer which concededly had an independent obligation to defend paid the balance of those expenses, plaintiff cannot show it suffered any contract damages. So we don't have to pay the 50% for Kaplan in the beginning. We had an attorney, we brought a defense, and we paid for that defense that you didn't want to participate in. More law. Moreover, when the insured refuses to accept the services of rightfully appointed defense counsel, no claim will lie against the appointing insurer for failing to participate in the defense. You didn't want our counsel. He was a perfect good counsel. We proved that. He was in Virginia. She already hired him. We accepted him. We wanted him to lead counsel. You refused to work for him with him, so that's not on us. That's on you. The insured refused to allow the insurer's appointed counsel to associate as defense counsel, asserting it was entitled to independent counsel of its own choosing, pursuant to civil code. That was proven false because they're in Virginia. After MBL defended itself, one insurer, so this is citing another case, Great American reimbursed MBL for the defense costs, while the remaining insurers refused. This is cite law. Accordingly, to the extent that such conduct amounts to a refusal of the defense through counsel rightfully appointed by New York Marine, it is also the case that neither the insured nor travelers has a valid claim for equitable contribution against New York Marine. Travelers also cannot state a valid claim for equitable relief because it admits that New York Marine has participated in the insurer's defense. That's obvious, right? Since Travelers' claim here is predicated on an allegation which concedes that New York Marine did provide a defense to the insured, just one that Travelers thinks was inadequate, it does not state a viable claim for relief. I always wonder where Robbie Kaplan came from. I think she saw this high-profile case. I think she volunteered to come in and say, hey, I want, basically she thought she could win the case and she wanted to use it because she'd also had a defamation case that she was working on to go against Trump. So I'm wondering if she came on, not voluntary pro bono, but just say, hey, I'd be good counsel for you. New York Marine's intent has no bearing on the viability of Travelers' claim for equitable contribution. In January 27th status conference, the court observed that although Travelers would not have standing to argue ineffective assistance of counsel or something of that sort, nevertheless, as the court understanding what Travelers is trying to do, to argue that there was affirmative position taken by the defense or by New York Marine not to provide a defense, and instead to just simply and improperly rely on Travelers' appointed counsel. Again, piggybacking. The court appears to correctly interpret Travelers' arguments, however, except to the extent that Travelers is actually asserting a claim for fraud, as addressed in more detail below. It makes no difference to the validity of its claim in this respect, and as an initial matter, intent simply isn't an element of breach of contract, which on the face of the First Amendment claim and the parties' respective arguments in response to the court's inquiries at the status meeting is what Travelers' claim is predicated upon. Fundamentally, Travelers attempts to recast an allegation that New York Marine breached its duty to provide an adequate defense for the insured as its own claim for equitable contribution would swallow the simple and well-established rule that only the parties to or the direct intended beneficiaries of a contract may state a claim predicated upon the enforcement of the contract. That would be Amber Heard. Traveler's argument ineffectively invites the court to create a new cause of action, and in doing so, abrogate centuries of well-established contract law. The court should decline to do so. Correspondence, this is important. Correspondence establishes that travelers cannot plead facts sufficient to support their claim because the allegations of paragraph 18 of the First Amendment claim, upon which its claim is predicated, are simply not true. The record of correspondence between New York Marine, its appointed defense counsel, and indeed Travelers itself establishes that not only are Travelers' allegations untrue, but that Travelers was aware that Cameron McAvoy was being cut out of the defense by the machinations of independent counsel, whom Travelers funded. So that would include Robbie Kaplan Rottenberg, and then after Kaplan left, then we're into Elaine Bredehoft and Rottenborn. They were also cutting Cameron out because Cameron McAvoy didn't leave until November 2020. But the Travelers nevertheless failed to require that independent counsel cooperate with Cameron McAvoy so as to permit that firm to participate actively in the insurer's defense. In this respect, the communications between New York Marine and Cameron McAvoy reflect that New York Marine went into the relationship with the justifiable expectation that Cameron McAvoy would be the lead counsel on the case. Thus, although New York Marine's correspondence acknowledged the need to cooperate with other counsel, it also stressed that it needs to be clear that your firm is lead counsel. This was made clear to Travelers in two separate emails, October 7, 2019 and November 13, 2019, on which Pamela Johnson, the claims professional handling the file for Travelers, the one who sat in the court every day for Amber, was included. New York Marine's position with respect to Cameron McAvoy's role was justifiable, both in light of the fact that Cameron McAvoy was initially retained by Amber Heard, and also in light of the proposition that an insurer which provides a defense without conflict is entitled to control the defense provided. However, the record reflects that notwithstanding New York Marine's intentions throughout the representation, independent counsel consistently and repeatedly refused to cooperate with or permit the Cameron McAvoy's firm active participation in the defense in ways both petty and profound. By way of example, on May 11, 2020 email, defense counsel from Cameron McAvoy observed that, quote, "There is no division of labor. I'm effectively local counsel to Kaplan Rottenborn and kept in the dark until help is needed. Requests for help often involve a local practice question or urgent filing deadlines. If there's supposed to be a division of labor, there is not one, and it's impossible for me to get involved because I'm not copied on emails, filing status, strategy, etc." Subsequently, defense counsel observed that because they had been removed from routine correspondence and filings, and we saw that on the motions, their names were left off, they were not even informed that the court had continued the trial date until they located the order so providing on the court document themselves. They had no idea they weren't going to case in a few weeks, trial in a few weeks. It got postponed and nobody told them. In fact, the record reflects that Cameron McAvoy actively sought assistance to obtain independent counsel's cooperation, most notably from Travelers itself. In this respect, Ms. Johnson of Travelers herself expressed concerns regarding the lack of cooperation and personally purportedly made efforts to obtain independent counsel's cooperation with Cameron McAvoy. On at least one occasion, Ms. Johnson directly addressed the issue with independent counsel, but as her own March 21st, 2020 email to Cameron admits, the conversation, quote, "did not go well." We're getting a lot of tea in this paragraph. This is Kaplan and Rottenborn now. In fact, as reflected in numerous subsequent emails from Cameron McAvoy to New York Marine, independent counsel never cooperated with Cameron McAvoy. Never. As a result, Cameron McAvoy ultimately requested and was granted leave to withdraw as counsel on November 6, 2020. Out of concern that independent counsel's consistent pattern of omitting them from correspondence, pleadings, and from strategic and tactical decisions, both great and small, not only rendered their participation futile, but exposed the firm itself to potential malpractice claims on account of decisions in which they had no say or involvement. Bing. Notably, under California law, Travelers could have legally required independent counsel to cooperate with Cameron McAvoy, but it truly desired to facilitate Cameron McAvoy's full participation in the insurer's defense. law, given the foregoing, travelers' claims should be dismissed on the basis that the communications between the parties admissible pursuant to the incorporation by reference doctrine reveal them to be without basis. Since travelers' allegation, we're almost to the end, guys, travelers' allegations amount to a claim of fraud, they are not stated with sufficient factual specificity, and therefore must be dismissed. That's a huge claim. As observed above, in addition to the allegations concerning the allegedly inadequate defense, Travelers also alleges that New York Marine has indicated that after trial, it will likely attempt to deny coverage for any award against a mutually insured based on its reservation of rights. Its reservation of rights, it says if you do this on purpose, if this is an intentional tort, we're not obligated to pay out toward the judgment. We're not obligated to pay the $1 million policy. In addition, Travelers alleges that New York Marine, has indicated cover the award of the mutual insured based on its reservation rights, and thereafter alleges that New York Marine's conduct was deceptive. In addition, Travelers alleges that New York Marine, while purporting to defend, actually had its defense counsel do next to nothing and piggyback on the work of the mutually insured's independent. Thus, read as a whole, the gravamen of Travelers' claims as alleged in those paragraphs may fairly be read to attempt to support the contribution claim by making allegations of fraud, inasmuch as the allegations suggest that New York Marine has made statements and or purported to undertake a duty to its insured, which in actuality it had and has no intention of fulfilling. That a promise was made with no intention of performing is actionable fraud where the other party relies upon it. It is an inducement to enter into an agreement. Okay, so as the court doubtless well knows, we've got all these rules and procedures, requires that when fraud is alleged, a party must state with particularity the circumstances constituting fraud. You can't just throw it out on the table. Well, they didn't do anything. And by the way, they're probably not going to pay out in the end, because they've got this reservations rights. Rule 9b demands that the circumstances constituting the alleged fraud be specific enough to give defendants notice of its particular misconduct, so that they can defend against the charge and not just deny that they've done anything wrong. To satisfy the standard, courts, including the Ninth Circuit, have stated that averments of fraud must be accompanied by the who, what, where, when, and how of misconduct charged. There are several reasons for this rule, including the usual concerns regarding notice and avoiding the use of such allegations as a pretext to the discovery of unknown wrongs. Most notably in the interest in prohibiting a plaintiff from unilaterally imposing upon the court that parties in society enormous social and economic costs, absent actual factual basis. Accordingly, if this court believes that Travelers' allegations may suffice to state a legally viable claim, it should at least require that Travelers plead those allegations with necessary specificity. Conclusion: for the reasons given in New York Marine's moving papers, its reply, this court's own well-reasoned order, the dismissal order, and the additional matters set forth herein, the court should order Travelers' claim dismissed without leave to amend. That was the mistake they made before. They didn't ask for without leave to amend, and then they did in fact amend it, or they're trying to with this one paragraph. Alternately, if the court believes that there may be some basis upon which Travelers' allegations may suffice to support its claim for equitable contribution, it should require Travelers to amend its complaint in order to more clearly allege the factual basis of its claims consistent with requirements of the federal rules of civil procedures, which require a minimum sufficient factual allegation establishing the plausibility of the claim. So there it is. A lot to read. I think what I find most important about this is a good lesson that there's always two sides to the coin, and they're both, well, Travelers, because they're they're trying to shock and awe the judge, like, I can't believe this happened. You got to help us. You got to help us get our money. And New York Marine is like, their claims are bogus. They're like out of the realm of reality here. We provided defense. Amber Heard picked the counsel, not us. I mean, we have the right to pick the counsel, but we picked the counsel that she did. A few more documents to continue this hit story. Shorter documents. All right, let's go back. So now we're going to have New York Marine James Wagner's his declaration. So we're going to get more of the story here. Following the withdrawal of Cameron McAvoy firm from the defense of the insured on November 6th, New York Marine and Travelers entered into a series of discussions concerning the ongoing handling of the insured's defense. The result of those discussions was an agreement pursuant to which New York Marine would reimburse Travelers 50% of the defense fees and costs it incurred from Cameron McAvoy's November 6th withdrawal. So from that point forward, consistent with that agreement, New York Marine obtained the invoices of independent counsel. That would have been Kaplan and Rottenborn. When they withdrew, that might have been November 20th. That would have been Elaine, right? Because Elaine came in after the trial. Consistent with the agreement, New York Marine obtained the invoices of independent counsel covering the period November 1st, 2020 to February 28th, 2021. So over a year. And as memorialized in the correspondence to Travelers, counsel, Mr. Peterson, made payment to Travelers on January 18th, 2022 in the amount of $621,000 and change, reflecting 50% of the fees and costs incurred by, there it is, Elaine Bredehoft for in connection with defense of the insured from November 6th, 2021 to February 2021. Not sure why they took a year to reimburse them. A true and correct copy of the correspondence. Nevertheless, as this litigation makes clear, Travelers continues to insist that New York Marine reimburse for its defense fees. So they didn't pay anything until January 2022. So when this file was originally filed by Travelers back early in 2021, it was true that they had not received any money from New York Marine because New York Marine was paying for Cameron McAvoy. Thereafter, on January 20th, 2022, following the status conference on the same date, Mr. Peterson emailed the undersigned counsel states as relevant as follows. Your cover letter sending the check, copy attached, states that this amount reflects reimbursement by New York Marine of 50% of the fees and costs paid by Travelers to Elaine for its services and costs incurred between November 6th and February 2021. I understand that New York Marine contends that it owes no contribution for fees or costs prior to November 6th. No, because they paid for Cameron McAvoy. The parties have briefed that issue, so positions are clear. Please explain how it is that February 28, 21 was used by New York Marine as the closing part of the 4-month time period reflected by this check. There was 11 months to go. Does New York Marine plan on paying 50% of the fees incurred in the 11 months after that and into the future? Does it contend that it doesn't owe those? If so, why? Is it agreeing to pay the fees incurred through this one law firm, but not other law firms? Because they still got Rottenborn. If so, why? Thank you for clarifying this. A true and correct copy of Mr. Peterson's email is attached. I'm not sure. Sometimes they do attachments separately. In response by letter, January 24th, we confirmed from Mr. Peterson that New York Marine's calculation was based on the amounts incurred by independent counsel from Cameron McAvoy's November 6th withdrawal and the exhaustion of purported capped fee agreement under which independent counsel had been retained by Travelers at the end of February 2021. As confirmed by Travelers, the letter further observed that New York Marine has agreed and continues to agree that it would participate with Travelers in the defense of Amber Heard by payment of 50% share of Travelers' panel rates. Now, in the letter, way back a few videos ago, Travelers said, we will pay this amount only based on Virginia typical costs. But instead, they were blowing money out the door, and whatever Kaplan and Rottenborn and now Elaine were filing, whatever they were billing, Travelers didn't put a cap. They were just paying everything. Oh, terrible. Panel rates, pursuant to which independent counsel had been retained following the abrogation of its purported capped fee agreement with Travelers in February 2021. A true and correct copy is attached. So the cap fee is saying, look, we're going to help you out, but you got to go back to the panel rates. How much do you think this is going to cost? I think it's going to be like $2.5 million. Remember, they were already covering Cameron. And they said, okay, well, that's the cap fee. We're not paying anymore. The January 24th, 2022 letter further confirmed that New York Marine was in the process of reviewing additional invoices reflecting work performed by counsel from the period March through May 2021, but noted that despite letters to counsel dated all these dates, neither New York Marine nor our office has been provided with copies of invoices reflecting the work performed. Yeah, you want 50% of our payment. You got to show us the invoices. And the invoices are going to show us. You're still letting them charge you too much money. And we have some exhibits. So again, we covered this. Here's the check. That was pretty much quoted above. They gave him a check to cover the expenses from November 6th through February 2021. There's the check. All good and dandy. At the hearing, please explain why you're not paying more. That was pretty much above. Please see the attached correspondence. This letter responds to your email of January 2022 following the conference with the court of the same date. As an initial matter, can you all see this? Can I go a little bit bigger and still fit it on the screen? I think I can. This letter responds to your email. As an initial matter, and with respect to your inquiry, how it was that February 28th was used by New York Marine at the closing part of the 4-month time period reflected by this check, that date was chosen based on Ms. Johnson's express representation via an email that after I pay February bill with Elaine, the capped fee will be exhausted. The exhaustion of the purported cap at the end of February 2021 is likewise confirmed in the budget March 1, 2021 through May 30th, 2022, prepared by Elaine and provided to New York Marine. So Elaine was told, we're capping you. That's all you're getting. Done. Prepared by Elaine and provided to New York Marine by Ms. Johnson, March of 2021. Email in which Ms. Elaine herself stated that the $2.5 million budget was used up through the end of February 2021. Finally, the exhaustion of the purported cap at the end of February 2021 was also confirmed by Travelers' own calculations and our own based on a review of the invoices received. With respect to your inquiries regarding fees incurred in the defense of the above referenced litigation since March 2021, as explained in our call and our letters, New York Marine has agreed and continues to agree that it would participate with Travelers in the defense of Amber Heard specifically, and again is set forth therein. New York Marine will make payments reflecting 50% share of Travelers' panel rate, which as agreed and referenced in the May agreement with Elaine's firm, where it's to be $320 per hour for partners. That would be Elaine, $255 for associates. Bredehoft was listed as a partner, and $115 for paralegals. Let's see what this little footnote says. As you know, the purported cap agreement memorialized in Travelers' June 10th letter to Elaine provided for payment of Elaine's firm usual rates instead of the more favorable panel rates upon which Travelers could have insisted, and that was in their original letter anyway, with the condition that the $2.5 million cap would cover all necessary work by that firm through post-trial motions. This is back in February 2021. Accordingly, and has been previously expressed, it remains inexplicable to New York Marine why the entirely predictable extension of the trial date necessitated a renegotiation of the agreement if it had ever been appropriate in the first place. Okay, so the trial was predicted to be extended because of the beer bug. That's what YouTube, just so I don't get nixed there. That was anticipated. Now, I saw a trial. I followed the Brooks Step one, and when it got postponed, when it got rescheduled, they had already completed all their work. They were ready to go to trial. So if they had completed their work and was ready to go to trial, the fact it was postponed another year, they should have been done. But if you go to the Fairfax website, you'll see, and law tubers have said, they've never seen so many motions filed in a case. And Elaine just buries and buries and buries Ben, hoping that they'll settle just to shut her up. New York Marine's share would be measured at a rate of $160 per hour for partners. This is the 50%. As noted in our letter, New York Marine also agreed that it was amenable to the use of Travelers' litigation guidelines and would take under advisement determinations made by Travelers with respect to the appropriateness of those invoices for payment. Though New York Marine reserved and continues to reserve its right to review defense counsel's invoices and to make an independent decision whether the time and services reflected therein were reasonable and necessary to Ms. Heard's defense. Nevertheless, as reflected in our multiple letters, and notwithstanding its repeated agreement to participate with travelers, neither New York Marine nor our office has been provided with copies of invoices reflecting all the work performed since March 2021. Now remember, they said they had a $2.5 million cap, and travelers already filed at, I think it was in April, they had, before the trial started in March, they had already spent over $6 million. So they're way above the cap. And somewhere afterwards, they claimed $8 million. So it sounds like they're hiding these invoices because they know they're not paying the panel rates. My speculation. And notwithstanding its repeated agreement to participate with travelers, neither New York Marine nor our office has been provided. New York Marine likewise has not received any status updates or other information concerning the present status of the defense and proceedings therein. Now remember, Pamela Johnson tried to make herself so important that she had to be in court every day because she had to have firsthand knowledge. She had to be there in case they needed her. And she's been participating with this defense, getting status reports weekly or whatever. Well, they're not handing anything over to New York Marine. Concerning the invoices covering work performed from March through May 2021, remember they paid through February, New York Marine has now received copies of those invoices directly from defense counsel. They got them right from Elaine. However, New York Marine has not received any information regarding the application of travelers' litigation guidelines, invoice review, or payment of those invoices. New York Marine is reviewing these invoices and at the same time is hereby requesting invoices from defense counsel from May 2021 to the present. If Travelers has made payments on any invoices reflecting work performed from March 2021 to the present and has any documents or correspondence addressing its payments, please provide them, and New York Marine will make payments as appropriate following its review. Likewise, to the extent that Travelers has any status reports regarding the present posture of the defense, we would appreciate those. Pam Johnson's not picking up her side of the bargain here. Not good. But they have something to say. Now Travelers is going to try and save their claim here. Plaintiff Travelers Commercial Insurance Company responds to defendant's further briefing support of its motion to dismiss Travelers' first amended complaint filed concurrently with objections to pro site's declarations. Why are you filing all these declarations now? That ain't right. It's not terribly long. A lot of law. On January 6th, the court granted ProSite, that's the underwriter for, I think that's the right word, for New York Marine, motion to dismiss Travelers' first amended complaint. The court's order did not address that one argument, section 3. And that's the part about Cameron McAvoy. Travelers asked the court to issue a further order addressing this. Court agreed and set a briefing schedule. So they had a briefing schedule, and they already jumped the gun with their ex parte at that last status meeting. ProSite invites the court to adjudicate the facts underlying the pleading with ProSite's evidence, but without Travelers' evidence or any discovery to challenge the evidence ProSite improperly attempts to submit in the context of motion of dismiss. Travelers objects to this. So you're supposed to bring your evidence to the trial. You've put it all in front of the jury. The jury is only supposed to rule on the legal facts, and it's supposed to presume that things stated in the motion are true until they're proven at court otherwise. And here they're submitting all this declarations and emails. The court should not consider ProSite's 3 declarations and their exhibits. ProSite, that's the emails, and that's their one declaration. Then there was 2 more declarations that we didn't see. One from Cameron McAvoy and one from the guy who actually wrote the letter, Battaglia. ProSite improperly submits 3 declarations which contain substantive testimony as well as emails and letters. This is not permissible in opposing a motion to dismiss. Concurrently with this filing, Travelers has filed an objection to these improper declarations. It urges the court to sustain its objection for the reasons stated therein. The court should deny ProSite's motion to dismiss. ProSite will be able to disprove Travelers' factual allegations. This is the arguments that they'll be able to prove them wrong. Mischaracterizations of Travelers' complaint as being one for breach of contract. So that's what they want motioned on. They want dismissal on. None of these arguments are appropriate or persuasive on a motion to dismiss. Moreover, none of ProSite's distractions change that Travelers' complaint adequately pleads its claim for equitable contribution and declaratory relief. Travelers' claims for equitable contribution and declaratory relief. Declaratory relief is judges tell us. Just decide. Although this is going to a jury. Just decide who pays who. Travelers' claims for equitable contribution and declaratory relief survive Prosite's motion to dismiss based on allegations that both Travelers and Prosite have a duty to defend their common insured and that Travelers has paid more than its fair share of defenses. The standard for dismissing a complaint on motion is stringent. As the court knows, the complaint does not need detailed factual allegations to survive dismissal. Again, that all comes at court, not at this level. Error bookmark not defined. I have no idea what that is. Therefore, the motion must be denied unless the complaint altogether fails to allege enough facts to state a claim for relief that is plausible on its face. And even if it appears that a recovery is very remote and unlikely, like, oh my God, just keep this alive and just spend all this money, even though we're pretty obviously wrong. That a recovery is very remote and unlikely. An insurer has the right to equitable contribution against other insurers where, one, they are co-insurers, meaning insurers of the same coverage level. They're not the same coverage level. Travelers is $500,000 and New York Marine is $1 million. And two, one insurer satisfies more than his fair share of the claim. The doctrine of equitable contribution grants an insurer that has paid a claim the right to recover from a co-insurer where both insurers were obligated to indemnify or defend the claim. The purpose of this rule of equity is to accomplish substantial justice by equalizing the common burden shared by co-insurers and to prevent one insurer from profiting at the expense of others. Equitable contribution claims allow for wide-reaching consideration by the court of all equitable factors. The court may consider numerous factors in making its determination, including the nature of the underlying claims, the relationship of the insured to the various insurers, and the particulars of each policy and any other equitable consideration. So, without question, Travelers' first amended complaint pleads sufficient facts to support a claim of equitable contribution as set forth in detail in the first amended complaint. Travelers asserts that both Travelers and Prosite owed a defense to their common insured for the same risk, and despite the common obligation, Travelers has paid more than its fair share. Nothing more need be alleged to state a claim for equitable contribution, but Travelers does allege more. Travelers alleges that Prosite had its appointed counsel do next to nothing in the defense and the insured and instead piggybacked it. So I think it's interesting that they can make this kind of claim, and even though New York Marine may have the proof that this is false, they can't present the proof now because that comes at the later stages in trial or summary judgment. Independent counsel paid by Travelers. In fact, Prosite's appointed counsel withdrew from representation November. They're still saying it's wrong. It's from November 6th. I mean, that's on the site. Is anything new here? Travelers has spent and continues to spend substantial sums toward the mutual's insurer's defense in the lawsuit, with independent defense counsel of mutual's insured choosing. The case continues and the amount incurred by Travelers continues to grow. For its part, rather than pay half, Prosite has not reimbursed the insured or Travelers anything. I don't think it's fair they say anything. Has not adequately funded a defense on its own. A very recent partial payment by Prosite changes this reality, but it does not satisfy the Prosite's obligation to contribute 50% of the defense, at least since November 20th, when it appointed counsel withdrew. Moreover, the partial payment does not include any interest Prosite owed. So they're stating their original claim here, and the footnote is saying, okay, yeah, they threw us a bone. In addition, as set forth in its prayer for relief, Travelers also seeks interest on the amount owed by Prosite. These allegations and the facts behind them must be considered by this court later in the litigation, past the pleading stage, to allow the court to determine in equity how much Prosite owes Travelers. Prosite audaciously states that an insurer cannot sue another for equitable contribution of the target insurer has paid anything at all. This is simply wrong, stating laws. In the insurance context, the right to contribution arises when several insurers are obligated to indemnify or defend the same loss or claim, and one insured has paid more than its share of loss to defend the action without any participation by the others. So we got more case law. Travelers has pled sufficient facts to support its claim for equitable contribution. The court should reject Prosite's attempts to mischaracterize Travelers' complaint in a desperate attempt to detract from the fact that Travelers has adequately pled claims for equitable contribution and declaratory relief. Prosite repeatedly mischaracterizes Travelers' complaint then argues that Travelers has not adequately pled claims. That's a lot of word salad in there. ProCite argues that Travelers can't use ProCites for breach of contract because it lacks standing. Travelers is not pursuing a contract claim against ProCite, so this argument amounts to nothing. Well, they threw it out there. ProCite itself makes Travelers' point. Numerous cases have reinforced the principle that an action for equitable contribution is rooted in equity, not contract. ProCite also argues that it can't be held vicariously liable for any legal malpractice or negligent conduct of defense counsel. We saw this with Adam Waldman and Johnny Depp, that there was, the court ruled that they were Adam was like standing in Johnny's shoes when he did stuff, so he was vicariously liable for anything that Johnny was vicariously liable for anything Adam did. Again, Travelers does not argue otherwise. This is another attempt by ProCite to mischaracterize Travelers' claims. Travelers pleads that ProCite compounded its breach of duty to defend by having its appointed counsel do next to nothing and piggyback on the work. That's a big difference than what they're able to prove if they were being intentionally left out. But again, that doesn't come at this stage, they're saying. This is an allegation of acts by ProCite. It is not a claim against lawyers, as explained above. Equitable contribution claims allow for wide-reaching consideration by the court of all equitable factors. Compelling equitable factors, they are properly included and they are relevant to ProCite's equitable obligations. ProCite also asks the court to view Travelers' equitable contribution claim as one for fraud. It then argues that Travelers has not adequately pled a claim for fraud. Travelers did not plead and did not intend to plead a claim for fraud. They're just couching it that way. Travelers is not obligated to meet the heightened pleading standard. ProCite also battles Travelers' non-existent claim for equitable subrogation. ProCite argues that since Travelers provided the mutual insured a defense, there are no damages to the insured to support a subrogation claim against ProCite. This is another distraction. Travelers did not plead and did not intend to plead a subrogation claim. An insurer which steps in for another insurer to protect their joint insured may not have an equitable subrogation claim because that joint insured has no damages to support such a claim. But the overperforming insurer, here Travelers, has an equitable contribution claim against the underperforming insurer, here ProCite. And the judge was the one who threw that out. It's like, based on what Travelers was claiming, why isn't Amber Heard suing New York Marine or Cameron McAvoy? ProCite also argues that it would respond to Travelers' non-existent subrogation claim if Travelers made one by arguing that the insured did not compel its independent attorneys to cooperate adequately with ProCite's appointed attorneys. In a supreme irony, ProCite cites California law and California cases as the foundation of its insured's duty to cooperate with ProCite's appointed attorneys, even as its motion is founded on its argument that the defense provides is not controlled by California law. This is, again, when they were saying they had to have independent counsel, but Virginia law says, no, they don't need independent counsel because there's no conflict of interest. We have rules to prevent that. Again, Travelers is not bringing a subrogation claim, so this argument has no relevance. ProCite also suggests that Travelers improperly bases its claim on ProCite's intent, which ProCite notes is not an element of contract claim. Travelers does no such thing, and because Travelers is not suing for breach of contract, remember they started to suggest that, and we're suggesting in the end they may not pay out at all. ProCite's argument has no bearing here because of their reserve of rights. We're at the end. We're getting there, guys. Then we got two short ones. ProCite also impermissibly argues that when ProCite's evidence is considered, evidence which it improperly proffers in this motion, remember the evidence comes at trial, not now, is what they're trying to say, it can defeat Travelers' claims as a matter of fact. Declaration of James Wagner, Stephen Battaglia, Battaglia is with New York Marine. Sean Project Roche is with Cameron. As indicated in section 2 above and in Travelers' concurrently filed objection, this is a pleading motion. They didn't upload those declarations. Let's see what we're going on. Because they didn't both share the obligation to provide a defense through independent counsel. This is another straw man argument. The court has ruled that ProCite did not have an obligation to provide a defense through independent counsel, but it did not rule that ProCite did not have an obligation to provide a defense at all. Travelers alleges that it did, and that ProCite acknowledged this. Travelers further alleges that ProSite did not meet its obligation to provide a defense, but rather ProSite defended inadequately prior to November 20th. It didn't defend at all from November 20th when its appointed counsel withdrew and ProSite did not replace them. ProSite was not reimbursed. ProSite has not reimbursed the insured or travelers anything and has not adequately funded a defense of its own. And we know that they have, and there'll probably be a footnote to that. They know they have given them some money. Travelers seeks the following declarations against ProSite. Alternatively, even if the court determines that ProSite was not obligated to defend the insured with independent defense counsel of insured's choosing, which they already determined in the dismissal, either because California law doesn't apply, which it doesn't, ProSite still breached its duty to defend the insured by failing to provide an inadequate defense because their guy left and because the failure includes not paying attorneys to do adequate work to defend the insured and not replacing the chosen Virginia attorneys at all when they withdrew. Well, Rottenborn was there, and they did say, look, we'll pay for half after he left. Even under the court's ruling that ProSite did not have an obligation to provide a defense through independent counsel, ProSite remained obligated to provide a defense of some kind, an adequate defense. It's a joint obligation, which supports Travelers' claim for equitable contribution. Travelers alleges that ProSite failed to perform or contribute to this joint obligation. Travelers alleges that ProSite failed in this both before and after November 20th. Travelers is obligated to contribute the defense. Travelers is funding. It does ProSite no good to say that it is only obligated to defend through appointed counsel, and if it fails to do even that. Travelers alleges that that is what happened here. Travelers has stated adequate claims for equitable contribution. So therefore, they're saying, don't dismiss our claim. Our claim for declaratory relief survives because Travelers has stated a claim for relief against ProSite for equitable contribution. It also stated a valid claim for declaratory judgment. ProSite's argument as to the dismissal of the declaratory judgment claim is part and parcel of its argument that Travelers is not entitled to equitable contribution because Travelers has adequately pled its claim for equitable contribution. God, if I have to say that again. Travelers' First Amendment complaint alleges sufficient facts to state claims upon which relief can be granted against ProSite. So they don't want it dismissed. They don't want it dismissed. Everybody get a drink. So then they also throw in a little motion that they're objecting to all the declarations that came in, the 3 declarations. We've covered that, I think. That, this is the time to do that. ProSite's public filing of these highly sensitive defense communications is a startling breach of trust by ProSite of the interests of its insured and those supporting her, including Travelers. While the purpose of this supplemental filing for ProSite and Travelers was not to have the court revisit its prior order on ProSite's motion to dismiss, ProSite just proved Travelers' point. ProSite's conduct is publicly sharing these very private communications demonstrates the conflicting interests between it and its insured, which entitles the insured to independent counsel, no matter that an argument can be made that a Virginia lawyer technically has no duties to the insured under the Virginia Code, professional responsibility. Now, I found a site where I'm getting documents for free. I think those declarations, if I went to Pacer Monitor, I would be able to buy them. That makes them still public, even though they're behind a paywall. So they're all upset, like, you're putting all this out in the public. We need privacy. And sadly, they're going to get it. And I don't think there's anything else new in this. There is no reason for the courts to consider the emails and letters proffered by ProSite. Further, the court's consideration of such material would, as the International Audio Text Court warned, convert this rule motion to an impermissible, improperly noticed motion for summary judgment. So they're saying that, hey, this isn't just their support of a dismissal. They're now doing a summary judgment. If they're going to do it, they need to do it properly. It's funny, I said that earlier. This is particularly unacceptable here, where the brief that ProSite submitted is a brief that was requested by the court on a narrow issue months after the central briefing. For documents other than declarations to be properly considered on the doctrine of incorporation by reference, the documents must be referred to in the complaint or form the basis of the plaintiff's complaint. The doctrine permits a court to consider the document if the plaintiff refers extensively to the document. So they just happen to fail to mention that we have all these documents that show that we're overcharging. we're paying overcharged. New York Marine and General Insurance Company's response to Travelers Commercial Insurance Company's objection to new evidence. I think we're going to get some dirt in here. And then that'll be it for today. Hang in there. On February 7th, New York Marine and General Insurance Company submitted its further briefing in response to Travelers' request for the order. On February 11th, Travelers Commercial Insurance submitted its opposition to New York Marine's brief. Travelers' objection asserts it objects to the three declarations and their exhibit in its entirety. We'll drop down. New York Marine's declarations are permissible. New York Marine submitted the declaration of James Wagner, Stephen Battaglia, and Sean Patrick Roche in part to authenticate documents which it seeks to admit pursuant to the incorporation of reference doctrine. Travelers' objection admits that the doctrine permits the court, in connection with a motion to dismiss under Rule 12b-6, to review documents referred to in the complaint, but not attached to it. As an initial matter, it is logical necessity that any document which was not filed by the plaintiff's complaint, but which was to be considered pursuant to the incorporation by reference doctrine, would necessarily have to be admitted and authenticated by way of the declaration, and courts therefore acknowledge the validity of a declaration, at least for the purposes of authenticating such documents. Thus was expressly stated in, they're going to cite code, and I think it's funny that Warner Brothers is involved in that site. Going back down, consequently, and contrary to Travelers' objection, New York Marine's declarations are admissible for the purpose of authenticating documents submitted for consideration pursuant to the incorporation of reference document. They inferred or referred to these things existing in their complaint. And they're like, well, yeah, now we're going to show you what really exists. We did not piggyback. Our poor guy was ignored. The allegations of Travelers' First Amendment complaint necessarily refer to New York Marine's instructions to its counsel. Travelers' objection understates the appropriate scope of the incorporation by reference doctrine. As construed by Travelers' incorporation of the various declarations and exhibits submitted by New York Marine, it's appropriate because the doctrine and incorporation by reference extends only to allow a court to have before it the full version of documents referred to in the complaint, but not attached to it. Rather, as stated by the Ninth Circuit, Knievel. Is that like Evil Knievel? We have extended the incorporation by reference doctrine to situations in which plaintiff's claim depends on the contents of documents. The defendant attaches the document to its motion to dismiss, and the parties do not dispute the authenticity of the document, even though the plaintiff does not explicitly allege the contents of the document to the complaint. Word salad. Lots of word salads here. Travelers' allegation that New York Marine had its appointed counsel provide an inadequate defense necessarily refers and relies on New York Marine's instructions to defense counsel. On January 19, 2022, Travelers filed its request for further order, which expressly requested that this court address the allegations of the First Amendment complaint and raised in its opposition to New York Marine's motion that New York Marine provided an inadequate defense to the insured. In turn, at the status conference, this court made specific and repeated reference to those allegations. Notably, the court also stated that to the extent that Travelers would not have standing to argue ineffective assistance of counsel or something of that sort, but then observed that it was the court, its understanding that what Travelers is trying to do is to argue that there was an affirmative position taken by the defense or by New York Marine not to provide a defense, and instead to just simply and improperly rely on Travelers' appointed cum as counsel. Oh my goodness. A lot of gamemanship here. At no time did Travelers' counsel contend that the court misrepresented its argument or otherwise seek to alter or redirect the court's focus. In sum, if Travelers is not alleging some intentional instruction by New York Marine to its defense counsel to next to nothing, then as this court has previously observed, it lacks standing to bring its claims for the allegedly inadequate defense, and its First Amendment claim should therefore be dismissed. On one hand, obviously, Travelers would not have standing to argue ineffective assistance of counsel or something of that sort. This is the judge saying this at the last hearing. If, however, Travelers' allegations are to be taken at face value, then the allegation that New York Marine had its appointed counsel do next to nothing necessarily refers to or relies on the New York Marine's instruction to its appointed counsel, and thus documents reflecting those communications are appropriately considered by this court by the way of incorporation by reference doctrine. Boy, they're really going to give it to them. Traveler's objection also takes the time to include an off-topic series of allegations that New York Marine's declarations and exhibits amount to a public filing, highly sensitive defense communications, which Travelers believes in somehow a breach of trust. Traveler's colloquy has no bearing on the merit of its objections, but is notably cynical example of its self-serving and hypocritical posturing throughout the underlying defense in this litigation. Put simply, Travelers initiated the present litigation, and Travelers asked the court to permit its claim to survive based on an express allegation that New York Marine directed its appointed defense counsel to provide an inadequate defense for insureds. Presumably then, if Travelers' claims are predicated on allegations of sufficient factual basis to survive dismissal, they will have to be tried on the basis of some evidence. Hey guys, you're mad at me for putting these emails out on a public filing, and yet it's okay for them in their public filing to claim that we committed some kind of fraud, that we told our counsel to do no work and piggyback. That's okay for them to put in a public claim, but not our defense that this is what really happened in a public claim. Travelers' allegations and arguments concerning sums allegedly still owed by New York Marine necessarily rely on documents submitted by New York Marine. Travelers' opposition also raises an argument that ProSite advised that it would pay 50% of fees and costs incurred by independent counsel on or after November 20th. Well, here's the documents. You put it in your motion. We're showing the documents. You referred to them. Travelers concedes that New York Marine has made payments to Travelers consistent with the alleged agreement. Nevertheless, it contends that the allegations relating to the alleged agreement and New York Marine's purported non-payment suffice to support its claims. In response, New York Marine submitted the declaration, which authenticated and attached correspondence to Travelers' counsel addressing the payments and the purported agreement of New York Marine, demonstrating that despite numerous requests from New York Marine, Travelers, contrary to their allegations of their First Amendment complaint, and its arguments, has simply failed to timely provide New York Marine with additional relevant invoices for invoices. Thus, Travelers' allegations of an incomplete payment directly rely upon the parties' agreement and conduct subsequent to that alleged agreement. As a result, the Wagner Declaration and attached correspondence, which directly address the parties' conduct on the account, are appropriate for consideration under the incorporation of reference doctrine. I'm learning a lot. That's what these videos are for. Deep dives. The court may appropriately convert the matter into a motion of summary judgment if it deems appropriate. Hey, if you want a summary judgment, let's do it. Let's do it now. Travelers' objection also asserts that the court's consideration of material submitted by way of New York Marines and the affidavits would convert this rule motion to an impermissible, improperly noticed motion for summary judgment. Travelers' objection omits that if the court believes the documents and declarations are appropriate for consideration, it may simply convert the motion to a properly noticed motion for summary judgment by granting Travelers the opportunity to respond. Careful what you ask for. Travelers' unsupported objection does not present any evidence supporting the inaccuracy or inauthenticity. I know that word. They can't claim it's inauthentic. They're not doing that. Of the correspondence submitted by New York Marine and its authenticity. Thank you. As observed above, Travelers contends that the various materials submitted by New York Marine may not be considered under the incorporation by reference doctrine because Travelers contest the authenticity of the documents and the accuracy of the declarations. So they're admitting it's all, what they're showing you is true and accurate, but we don't want you to see it right now. As the case addresses the incorporation of reference and doctrine make clear, merely asserting that we object is not a sufficient basis upon which to preclude admission of documents under the doctrine. Rather, a party objecting to the consideration of documents must provide an evidentiary basis for the alleged inaccuracy or inauthenticity of the documents for which consideration is sought. You can't argue these documents are true and accurate, and you've made these claims to us in your motions, and you claim we didn't pay you, and you claim we didn't agree to pay you, and you claim that we committed some kind of fraud by telling our counsel not to. These are the documents of reference, and they're true and accurate and authentic. Moreover, Traveler's objection is self-serving, without basis, and insufficient and self-evident. 3 of the emails which New York Marine seeks consideration of originated from or were sent to Traveler's own claims professional, Pamela Johnson. Accordingly, the lack of any declaration by Ms. Johnson or counsel asserting the lack of accuracy and or authenticity of those emails is tantamount to an admission that Traveler's objection to their accuracy and authenticity is without merit. She wrote the emails. Pamela Johnson's the one who wrote and received the emails. If you got a problem with her, where's her declaration saying that these are not authentic? Would appear to flirt with the express misrepresentation to the court. Big shade. Setting aside the blatant and self-serving nature of Traveler's unsupported claim that it cannot verify the accuracy or authenticity of emails to and from its own claims professional, who has previously submitted a declaration in this action, so it's not like she hasn't done this before. Travelers also offers no reason to question the authenticity of the remaining documents or suggesting why the sworn declarations provided by New York Marine do not adequately authenticate the documents submitted. For each of these reasons set forth, and for the reasons stated in New York Marine's further briefing and response, which we kind of followed, request for further order, Travelers' objections to the declaration exhibits submitted by New York Marine in support of its further briefing should be overruled. Should be overruled. February 14, 2022. We're getting really close to the trial. Of course, they all think they're going to win. They all think we're going to win. So this is about where we're at here. Okay, so we're getting close to the end of this saga where they're in discovery now. Let's see. I don't think there's been any updates. I'll check it while I'm here. Nope, it's still in discovery. And that's what we're waiting on. So I know I hope you like this deep dive. I know some people don't love the reading of documents, but you know what you're getting before you get in the video. There's a lot of tea in there. There's a lot of shade. There's a lot of allegations. There's a lot of storytelling. I mean, at the beginning, Travelers was making a clear story that New York Marine did nothing. Now we're finding out, oh yeah, we did. And y'all wouldn't talk to our counsel. And their first claim was dismissed, and they did an amended claim. And it's all centering on, okay, well, your counsel left because it was inadequate, or no, it's because you ignored them. So now you got to pay us half. Well, we'll pay you half, but we're not paying the lottery you're giving Elaine Bredehoft. We're paying basic rates. So that's where we are for today. We'll have more insurance saga coming. As far as the one New York Marine versus Amber Heard, it is confirmed she did sell her house, and her whereabouts for us is unknown. And I wonder if her whereabouts are unknown to New York Marine, because it does not seem that they have served her yet. They have not filed proof of service. So her 21 days to respond starts when she gets served. So we're waiting for updates there. So I wonder where she is. I don't know. I got a crazy hair right here. There it is. It's got its own mind. All right, so that's all I got for today. I'm going to try and do a live Tuesday or Wednesday to go over the unsealed documents. And let me tell you, this is daunting. It's like, I don't even know where to begin. But I put out a ton of tweets and excerpts. And I think that's the best way is just to use those bite-sized chunks and find out what you're interested in if you want more of a deep dive. And also maybe to debunk some of those things we've seen out there, because we've seen a lot of misinformation. A lot of outright cherry picking. I mean, literally cropping off Johnny's and Amber's name and trying to switch the conversation. That's how blatant we've seen. So that'll be coming up. Look forward to that. And thank you for coming here today. Please like, subscribe, share, help my channel grow, and I can keep bringing more information. So thanks, and have a great rest of your day.